Hello, everyone. Happy to be here with you today. I'm Nancy Tubbs. I'm an attorney. I've been working in the area of education law for the last more than 20 years. My main focus has been on students with disabilities. And during the course of my work with these students and their families, especially for families with language diversity, parents not being fluent in English, the issue of language access has come up again and again, and that is why I've gotten involved in it. It's the issue of, what does justice look like for both a child who's not a native English speaker, who's in a public school, and has the right to succeed just like any other student, but has a language difference. And also their families. We know that the families need to participate, need to advocate for their kids, and language barriers make this very, very difficult. So language access justice means basically equal and meaningful participation in the programs. So I think the most useful question to ask is usually, what does the student need to succeed in school? If English is not their first language, and maybe the needs are not only their own needs, but the needs of the family. So what are the needs of the parents in terms of communicating with the school? So in terms of just sort of getting our arms around what the problem is, we're looking at about almost 10% of the public school population in the country being what we call English language learners. There are some other ways of referring to these students that I think are preferred, but I'm going to just pretty much stick to the way the law speaks about English learners. And the reason I'm going to stick to the language in my presentation is that what I have found in my advocacy is that it's really important to use the terms that are used in the law if you are advocating under the law. And I'll just sort of leave it at that, because language does matter. Often what I have found is that school administrators and so forth, they look for keywords. So one of the major keywords, of course, is an English learner. So we've got 10% of the student population, most of whom have been born in the United States. So certainly this doesn't just mean students born in other countries. Most of them are born here, but their first language is not English. And the majority of those students in the country have Spanish as their first language, but there are many, many other languages. Okay, so when we start thinking about this, I think it's really important for everybody to be looking for evidence that the English language learners in the public school district that we're dealing with, to see whether they are succeeding or not succeeding. So how are we going to see this? Well, we can look at statistics on graduation rates that show that graduation rates, the most recent statistics show much lower graduation rates. We're seeing higher dropout rates among students who are English learners, lower standardized test scores, less overall college readiness, significant drops in achievement during COVID, by the way, and less likely to be identified in gifted programs or advanced academic programs in the school. And if the state has more than one diploma for graduation, as we do in Virginia, where I've practiced, we've been seeing that far fewer English learners are getting the higher diploma. So there's a whole network of law, and this is true of many areas of education law. We don't have just one source. So it's sort of like a puzzle that fits together. Probably the most prominent piece, of course, would be federal legislation, and I'm going to go through the major federal laws. But there are also state and local laws. Now, I'm not going to speak specifically to Missouri or any other state. So if you're in Missouri or another state, you'd have to check to see what your state and local laws or ordinances are. But basically, we start out with the United States Constitution, and federal legislation that has been adopted since the 1960s. We also have US Department of Education guidance and Department of Justice guidance. That's very important for really explaining and elaborating exactly what school districts must do. And I'll be giving you a link to the most recent agency guidance on language access. Another thing that I find very useful is to try to track what the federal government has done to enforce language access rules. And that you can find this online. You can find settlement agreements that the Department of Justice has entered into as a result of the investigations that they've brought against many school districts in the country. And these settlement agreements are very detailed. They really cover a lot of ground in terms of what schools must provide under language access law. And so you can see what the Department of Justice is really getting in terms of these settlement agreements, getting school districts to agree to do. There's been some legislative studies. We did one in Virginia a couple of years ago. If there has not been one done in Missouri in recent years or wherever you are, I would encourage you to try to see if you can get your state legislature to authorize one. We did that in Virginia. It was in 2021. And it really did show that language learners have suffered disproportionately much more during COVID than other learners. We also do have some case law. So cases have been brought by individuals as well as by classes of groups or class action suits. These cases tend to be extremely complicated, and they tend to take place over many, many years. I'm not going to be getting into too many details on that, except just maybe the major cases. So I mentioned the United States Constitution. If they grow up speaking another language, that language essentially is associated with ethnicity or national origin. So the language that they speak, their primary language, is essentially a proxy for national origin. All right, so they have the right to equal protection under the law. They may not be treated differently or unfairly based on their race, ethnicity, national origin, or other protected characteristic. Okay. So what are the two basic guarantees of the Equal Protection Clause for English learners? One is no segregation. So you can't, it would be illegal for a school division to take their Spanish-speaking, native Spanish-speaking students and place them into an alternative program. There was a case brought on this a few years ago in Virginia, and essentially what they were doing was the school district was grouping the older students who had come from Latin America into an alternative program because they were already teenagers and they they had similar needs. But that was not found to be legitimate. These students had to be given options to be in the regular schools. Aside from no segregation, the other major right is they have the right to services that they need to succeed in school. So this will look like having English language classes. They have to be taught as students who are not native speakers. So the key legislation for language access law is Title VI of the Civil Rights Act of 1964, the Equal Educational Opportunities Act, and that was passed in 1974. The Every Student Succeeds Act, ESSA, also came from the 60s. So all these laws are, more than 30, 40 years old. They've been around a really long time. What's very significant to keep up with, though, is the key federal guidance. And the key federal guidance right now was issued on January 7th, 2015, jointly by the Department of Justice and the Office of Civil Rights within the US Department of Education. And like I said, I'm going to give you a link to that at the end. So the major Supreme Court case on this, on language access, was Lau versus Nichols. This was a class action that was brought in San Francisco against the San Francisco School District on behalf of Chinese American students. They were not being provided with English classes, English instruction for their needs as students who had the native language of Chinese. And so the court basically said that they were effectively foreclosed from any type of meaningful education because they were not being instructed in English. So that case was brought under the Civil Rights Act of 1964. And that law basically says that any program that's getting federal financial assistance is covered by the Civil Rights Act. If it's a private school that accepts any form of federal financial aid, including aid in kind, which might be supplies of some kind or could almost be anything, then the Civil Rights Act of 1964 applies, language access rights apply to that school. So this really would prohibit any exclusion of an English learner from effective participation in an educational program offered by the district. And this could be any education program at all. So it's important to think about the extracurricular programs as well as all of the other educational programs to make sure that every single program is accessible to that English learner. The school must take affirmative steps to overcome the language barrier. So when I say affirmative steps, it's not enough for a school to sort of wait for somebody to complain. They have to create an effective plan to address English learner rights from the first instance, and that plan must be comprehensive. And then they also must have a mechanism for taking complaints and making changes as needed. Okay, so I mentioned a little bit about enforcement. It seems to me in my practice that most of the enforcement of language access is being done by the Department of Justice and the Office of Civil Rights. So these are federal agencies. It's not easy to bring an individual case against a school district, but it is possible. But the enforcement by the Department of Justice is extremely important. If complaints are brought to the U.S. Office of the Attorney General's office, I mean, they will look at those complaints. This is what we did in Virginia. We spoke to that office and we told them about, you know, how rarely some of our clients were getting interpreters or qualified interpreters. They weren't being given translated materials. And an investigation was carried out and a settlement agreement was reached with one of our major school districts. So when there's an investigation, they're going to look at whether the school district is providing the specialized language service programs that are needed. Are they identifying the English learners? Are they placing those learners in programs? Are the services really being delivered? Are the programs effective? So they have to monitor and make sure that these students are actually succeeding. So the Equal Educational Opportunities Act was passed after that Lau versus Nichols Supreme Court case. This is the statute that provides a direct right of action. So a parent can bring a lawsuit under the Equal Educational Opportunities Act against a school district if language access services are not being provided adequately for that student to succeed. And the language in this statute basically says that the school district must take appropriate action to overcome language barriers that impede the full participation of an English learner student in instructional programs in that school district. So we've seen some class actions as well as individual suits brought in different places across the country under the EEOA. Okay, so there is a test that has been developed in the Castaneda case, a federal case. And in this case, basically, they've set out a three-part test to evaluate whether a school district is providing adequate English language programs for English learners. So they're looking at three things. First thing is they're going to look at that program. And by the way, the reason they're looking at programs is because it's not mandated. There's no one program that's mandated by federal law. So the school district gets to choose, you know, how to address the needs of these English learners. But when a case is brought, if a case is brought against the school district, the court is going to look to see, first of all, if that program is based on sound educational theory. If it is, they're going to look to see if it's being implemented appropriately. So, they're going to look at, have they hired sufficient teachers? Do they have materials? Things like that. And then the third thing is results. So the school district must show that these students are actually overcoming their language barriers and they're able to succeed in the programs. So the Every Student Succeeds Act has a lot of very detailed requirements on schools. It addresses things like identification and assessment of English learners, what appropriate placement and appropriate language instruction looks like. It covers things like professional development, also parent and family engagement, which is an extremely important aspect of language access law, is when a school district is addressing language access for the students, they should be engaging the community, involving parents, involving other stakeholders. And so the ESSA is a good source for getting very detailed information about what a school district should be doing. Also, it is the source for federal funding for English language programs. There are Title III grants that school divisions can apply for to fund these programs. I mentioned identification. English learner students must be identified within 30 days of their enrollment. So this is usually done by a home language questionnaire. Of course, those questionnaires have to be accessible. So there should also be things like, signage and other ways that school districts are reaching out to parents to make sure that this connection is made in the school district identifies every English learner in the school. The English language proficiency screenings, there are different ones depending on the program that's being used, but these proficiency screenings must be carried out every year. They are mandatory. There is an opt-out available to parents, but even when parents opt out, the school districts are still required to do some monitoring of the students. So every school district must have a written language access plan. So this plan has to say how their English learner students are going to become proficient. How are they going to attain the requirements for graduation? And how are they going to promote family and community engagement? Schools must communicate with parents in the parents' native language about matters that they communicate with English-speaking parents. So we talk about essential information, and I think I've got a separate slide on that I'll come to. Interpretation and translation services for parents must be provided in major languages. The idea of major languages is that the school district is supposed to carry out a process of determining what languages are spoken in that school district. And when there is a need, they must address it. There is no absolute formula for determining the exact number of students or families that must be of a certain language in order to have to provide services. There's some guidelines, but I think it's best to keep in mind that really all parents are going to be entitled to interpretation and translation services. Essential information is, this is perhaps fairly intuitive. I mean, it's things that all parents want. They want to know what their child's grades are. They want to know what the academic options are for the students. What are the courses being provided in the school? What forms do they have to fill out? The forms should be provided in at least in the major languages that the school division has identified. Notices, school discipline notices, any kind of form related to students with special needs, like students who have IEPs or 504 plans. Anytime the school is issuing a specific notice to the family about the student, it should be in that in the primary language of the parent if they're writing to the parent. But then other things that are just general information should also be provided in those major languages that the school district has identified. Ensuring meaningful communication with, there's another term that's being used in the law, which is limited English proficient parents. I know there's a better term. We're going to be getting around to that in the next presentation. But these are basically, the parents that have been identified through those home language surveys. And they need to be identified so that the school knows to provide access. And language access means using appropriate and competent translators and interpreters to communicate with those parents. What does that mean? It means that the translators and interpreters have to be proficient in the targeted language. They must have a certain ease of written and oral expression. They must have knowledge of specialized terms. We know that there are a lot of specialized terminology used in schools. Perhaps, you can think of students who have disabilities. There are lots of different terms related to those disabilities. A lot of terms used in IEPs that these translators and interpreters must know. They must have training. So it's not only training in the role, but there's confidentiality protections in school that they need to know about. And they also need to know, they need to learn about what is the code of ethics that applies to their work as translators or interpreters. So civil rights issues that have come up for language access in complaints that have been made, or investigations, I should say, that have been conducted by the Department of Justice or the Office of Civil Rights. They've looked at things like, are schools properly identifying all the English learners? Are they providing effective language assistance programs? And these are not only for teaching English, but it's also for communicating with the English learners themselves about their education and communicating with the parents. Are they staffing and supporting the English learner programs effectively? Do they have enough teachers? Are they being given meaningful access to all the programs? So do they have interpreters available for clubs and sports and things like that? Are they unnecessarily segregating some students? Are students being given the right services to be in those advanced classes? Special education issues, which I'm going to come to in a moment. Are they giving parents notice that they have the right to opt out? Are they monitoring the students? Are they evaluating the effectiveness of the program? Can they show that their program is working? And finally, are they communicating meaningfully with those parents? Are the parents getting the information that they need? So schools have overlapping legal obligations. Okay, so students who have special needs are covered under one or both of these laws. Section 504 of the Rehabilitation Act of 1973. This is the broader of the two laws. This protects students who have any physical or mental impairment that substantially limits one or more life activities, and life activities include learning, concentrating, thinking, and a whole host of others like walking and breathing and things like that. So that's a very general one. The more specific one, or a slightly narrower one, is the Individuals with Disabilities Education Act. So essentially, this covers students who need specialized instruction in order to be successful in school. And often they also need, related services like speech therapy or physical therapy, or occupational therapy. So of course, there's a big overlap. There's an overlap certainly between students who are covered by Section 504 or the Individuals with Disabilities Education Act and English learners. This area really presents tremendous needs in the area of language access, because there's a lot of communication that needs to take place between the family and the school. Basically, rights under these laws are worked out in meetings and negotiations. And obviously that involves a great deal of communication. So what do the schools have to do for English learners with disabilities? They certainly have to identify them using instruments and tests that do not discriminate against them on the basis of their language difference. So if a native Spanish speaking student needs to be evaluated in Spanish, they must provide that evaluator. If a English learner student has an IEP, their language learning needs must be addressed in the IEP. And they also must be addressed separately from the IEP. So the IEP isn't going to necessarily cover everything. They have to provide services that are language access services as well as IEP services. They should have an ESL teacher. If they're providing ESL services, that teacher should be part of the team that meets to plan the IEP for the student or the 504 plan for the student. They should be providing services that are culturally and linguistically responsive. They must monitor progress both on language acquisition as well as progress on overcoming the disability. And as we said before, evaluate the effectiveness. So there was a class action that was brought a couple of years ago in Chicago, where a group of students alleged that Chicago did not have a policy or practice of ensuring that the parents received competent interpretation and translation services. So this was a fairly successful case against this school system. The court found that they alleged that there was an express policy practice of providing interpretation services by impartial interpreters. I'm sorry, this is what was required. The express policy and practice of providing interpretation services by impartial interpreters at IEP meetings. They had to have a protocol to identify the LEP parents, and they had to notify the LEP parents in writing of their right to receive translated IEPs. So this is what the court basically said. It did go into a settlement. I believe it's still being overseen by the courts, but basically they passed that hurdle of making a claim, and the school district wasn't able to just simply dismiss the claim. So it did result in effective settlement negotiations between the group and the school system. Arlington County, I mentioned before that we had an investigation and a settlement agreement in Virginia, and it was Arlington County Schools. It resulted in a very, very long and detailed settlement agreement. I wanted to point out some of the things that came out of that. First was the written translations of all IEP related forms. So everything had to be translated. Also written translations of the child specific documents, which in the area of special needs, it can be a psychological report, a speech language report, certainly the IEP itself or the Section 504 plan itself. So this settlement agreement required the school district to do written translations. So not just having an oral interpreter read something. And there were specific deadlines in the settlement agreement for these translations. So some proposed policy solutions. You know, I think investment in community-based organizations that serve ELs, I think community-based organizations can be very effective in trying to, reach out to the parents, find in specific language groups perhaps, and find out, are the parents being served, and can their needs be brought in some kind of collective way to, let the school districts know that they need to do a better job. There should be incentives for schools to hire diverse teachers. Schools are allowed to hire diverse teachers to staff ESL programs. They should be providing more professional development. They should be providing more targeted state support. You may want to look into what is the state funding for ELs. I say here that in 2021-2022 school year, the national average was a 39% state supplement for English learners. Now, when we did a look into what Virginia was doing, they were only providing a 13.5% funding supplement for EL students. So that's way off the mark. Okay, how to get more information? Like I said before, I would recommend going to websites for the Office of Civil Rights or the Department of Justice, taking a look at what their guidance documents say about language access. So on the right here, this is a link to the Arlington settlement. If you go to this link, you can also find a listing of all the other settlement agreements. Thank you very much for listening.